Cox Cable Channel 3.
The legal system can be confusing and frightening to a person who does not have the legal training and is caught up in it for the first time. Add to that, you're incapacitated or underage. Our legal affairs contributor Craig Wisnam joins us now with personal injury information you need to know for minors and incapacitated adults. You say that the attorney in this case needs to work through the probate court? Why?
Well, if something happens to you, you get in an accident, hurt your leg, you might go see a personal injury attorney.
Right.
They handle the case for you. They come to you and say, Martha, they've offered us this much money. Should we pursue it? What should we do? But when you have someone like a minor, child who can't legally make decisions, or maybe you have someone who might be mentally incapacitated, maybe they got brain injury or something had to do with what the lawsuit involves, you need someone to look out for those people. And the court does this normally by appointing what we call a conservator to protect the assets and the rights of someone who can't protect themselves.
And how does the conservator do that?
Well, the conservator kind of steps into the place of the person who can't make decisions themselves. Let's say it's a minor child, a 3 or 4 year old.
Why couldn't parents make that decision?
Well, the parents aren't legally, they're not legally empowered to completely deal with all of the minor's assets, especially as they move upwards in terms of value. In other words, they can handle a small checking account or birthday gifts from the aunt legally, but if there is a multi-million-dollar settlement, the court wants to appoint someone. That can be the parent. A parent can often be appointed as the conservator. The problem with that is the court wants to make sure that person is creditworthy and has the financial wherewithal that if they do something wrong, there's protection. And the court requires a bond that that person posts so that if they do something wrong, that minor or that incapacitated person's assets are protected. Sometimes a lot of individuals aren't able credit-wise to get bonded for really significant amounts.
So all this happens, the choosing of the conservator and so forth, before the actual situation, the lawsuit happens?
It depends. It's normally best if it happens as soon as possible because, for instance, if from the personal injury attorney's point of view, if the jury or whoever else might be deciding the case knows there's someone independent trying to make good decisions with that minor or that incapacitated person's money, it's much better than if they think it might be wasted by someone who's not as responsible.
So this award would go into a voluntary trust?
Well, normally if it's a person who truly can't make decisions for themselves, it stays in the conservatorship, and that's the other side. Well, it's necessary. If there's $3 million, someone has to take care of it until the child reaches age 18 or something like that. However, even for those people who are legally capable, you deal with people who may not have the financial expertise to deal with suddenly more money than they've ever seen in their life, and they also have to realize that's probably budgeted to take care of themselves or someone else in their life for a long period. So sometimes they might want to go with a professional as trustee to take care of that money for them, help them along with it.
Okay, Craig, thank you so very much.
Thank you, Martha.
For your money.